going inside the issues of our community. This is Local 12 Newsmakers.
Good morning and welcome to Local 12 Newsmakers. Last week I had Christopher Smitherman, the president of the NAACP, and Sean Ruggles, the president of the African American Chamber of Commerce, on the show to discuss the criticism of the city for not utilizing more minority contractors on city-financed jobs. Immediately after the show, I got an email from Ed Rigaud, the former president of the National Underground Railroad Freedom Center. Ed suggested that the Freedom Center's success in including minority contractors, nearly 40% of the construction work was contracted out to minority firms, could be used as a case study for what it takes to be successful in incorporating minority firms. Unfortunately, Ed is not in town this week, but he suggested that I invite the attorney who guided the process of identifying and selecting the construction firms to build the $110 million Freedom Center project. I am joined now by Stephen Justice. Mr. Justice is a graduate of the UC College of Law and clerked for federal judge Nathaniel Jones in the mid-1990s when the Freedom Center was first taking shape with the help of Judge Jones. Mr. Justice then became an attorney with Taft, Titinius & Hollister and is now a partner in the Dayton office. Stephen, welcome, I think, back to Newsmakers. I think you were here one earlier time.
Yes,
and thank you for coming down from Dayton this morning.
Good to be with you.
Okay, you know, the focus here is there's sort of a social goal of including minority firms more integrally into these big projects and how to do that. Back in the early 2000s, when this was taking place, when the Freedom Center was moving towards construction, Cincinnati found itself in court and set-asides for minority firms were thrown out. And the focus was on small business enterprises, SBEs. What was the theory here? What was the sort of the operative framework that you were operating in?
Well, we were asked to assist the Freedom Center in coming up with an inclusive project that would be diverse and would involve small business enterprises that could be owned by minorities or owned by women, and also to diversify the actual workforce laborers on the project. So we were asked to come up with literally race-neutral means to accomplish that. The Freedom Center didn't want to get embroiled in a lawsuit being accused of racial discrimination in terms of its contracting processes. So what we did was we met with contractors and we began to just talk to them and find out what are the practical problems or barriers that they face in terms of getting involved in large projects like this. And really what we learned was that there were a number of practical race-neutral solutions to these issues. It really wasn't rocket science by any shape or form. It was just a matter of looking at the problems and coming up with common sense solutions. So to do that, we implemented a number of steps. The first thing we did was we realized that the pattern of having a few large contracts was a barrier. Lots of times smaller contractors have cash flow problems, they have problems getting bonding for large monetary sums for big contracts. So the Freedom Center made a decision at the outset that instead of having a few large construction contracts, we're going to break out this project into literally 52 separate trade contracts. On top of that, they said, let's not only break them out, but let's make the affirmative choice to actually buy some of the materials directly. The Freedom Center would buy them. And what that did was it lowered the price of the contracts. Instead of the contractor having to go out and buy the materials as well as do the labor, they could actually buy less materials, or in some senses buy no materials at all. Some of the contracts ended up being just labor-only contracts. So this allowed a large number of small business enterprises, both minority-owned and women-owned, to actually bid on these contracts.
So the point is you're breaking these up. Now, from the owner's point of view, in this case the Freedom Center itself, it's simpler to just have a couple of master contracts and then sort of encourage those big contractors to go out and find subs that are minorities, but you decided that wouldn't really work?
Well, no, it would have worked. I mean, that's the way probably it's typically done. But the Freedom Center made an affirmative choice, and really I think the thing you learn from this is that these construction projects are owner-driven. You know, the owner can decide how they want to handle this, and the Freedom Center said, listen, let's do it in a different way and see if we can be inclusive. And so that's what they did. There were still some large contracts. I mean, some of them just didn't make sense. With the stone, a lot of the structural materials were big contracts. And so with the larger contracts, we encouraged the larger contractors to partner with smaller contractors or to team together, to find other smaller business enterprises, whether minority-owned or women-owned, that they could team with to bid together on the larger contracts. So yes, you typically see a bundling of a few projects, or a few contracts, I mean. The Freedom Center said, no, let's spread it out and include more people.
Now, you know, big contracting firms, or big firms in any area, they not only have the ability to do a job, but they also have the ability to find the jobs and to track what is available in the marketplace. A lot of small businesses, they may be very good at doing something, but they're not as good at even knowing what's out there to bid on. What did the Freedom Center do to overcome that problem, to actually let people know that they were being invited into this process?
Absolutely. We found that was another significant barrier to inclusion, is just getting the information out. So we decided to literally take the project on the road, and we did a regional tour of 4 cities in this area. We went over to Indianapolis, up to Dayton, obviously here in Cincinnati, Northern Kentucky. I think there may have even been a meeting in Cleveland. But the effort was sponsored by the African American Chamber of Commerce and other local groups. And we literally took these pre-bid meetings out into the neighborhoods where a lot of the smaller contractors would live and work.
So in churches, Union Hall, that type of stuff?
Urban League locations, absolutely. We also did some in hotel settings. We did a variety. I mean, this was an effort to include not only large contractors but also small contractors, and it was amazing. It really did facilitate a lot more participation. Then at those meetings, we asked the Ohio Department of Development to send down representatives from their minority business. They had a minority business bonding assistance program. And it was tailor-made to help smaller contractors, in this case that were minority-owned, who had had trouble getting bonding for projects.
For those of us who aren't in your legal world, why do you need bonding? What is bonding and why do you need it?
Well, in the process of bidding on a project, you have to obtain a bond, in other words, to assure the owner that you're going to have the resources to be able to do the work that you're contracting to do. So, you know, it's a normal part of the construction bidding process to be able to obtain a bond for the work that you're going to do. And many times small business enterprises have difficulty getting bonding. So this program allowed a minority-owned enterprise actually to go through an educational process which helped them to understand really how to run their business, how to get their business in order, and then the carrot at the end of the trail was that if they went through the educational process, they were guaranteed bonding through this program. So representatives from that program came to these pre-bid meetings. If any of the contractors had questions or wanted to be a part of that, they could meet with them, and they could actually then follow up and get into this program, and many of them actually did.
So even the idea of breaking up the contracts into smaller bid packages, even identifying potential bidders, all of that wasn't enough. It's actually going out and helping, or at least finding the agency that could then help these private businesses get ready to bid on these contracts.
Absolutely.
So all of that's part of the commitment of, in this case, the Freedom Center, but the owner of the project.
Absolutely, and really the idea is that this is something that any owner could choose to do. I mean, these are all race-neutral means in essence for owners, if they wish. If they come at this with that perspective, they could implement the same paradigm and build a big project today using the same means. Is
it more expensive to do it this way, though?
Well, yes, it may involve some additional cost, and it may involve some additional time, but not a lot. I mean, you have to weigh it. What are we communicating in our society today? Do we want to be inclusive? Do we want to be diverse? Do we want to have small business enterprises involved in these projects? If that's true, then we need to facilitate that. And I mean, not only the bonding assistance, but they also provided technical assistance. I mean, the construction manager was asked to answer any questions that any of the contractors had throughout the entire bid process, to literally explain the forms, to explain how the bidding process worked to new entities that might want to bid on this project. So there were a lot of factors that added into making this a very small business enterprise friendly exercise, and and it was very successful.
You know, one of the questions is there's the small business enterprises, SBEs, then there's the minority-owned enterprises, which frequently, sometimes are larger, but frequently are small. When we use figures of participation in the Freedom Center project, and the Freedom Center says it was close to 40%. We're talking about minority, not just, we're not mixing. Sometimes the criticism is, well, it's a lot of women who get the, women-owned firms who get these. They're really not African-American owned or other ethnically minority-owned firms. Are we talking about these are minority-owned firms?
Yeah, my recollection was that the vast majority of those were minority-owned enterprises. I mean, even some of the major contracts were actually awarded to minority-owned enterprises. So I'm sure there were some women-owned enterprises involved in the process. But you know, there was a study conducted by the University of Cincinnati on the results of the Freedom Center project in this regard. And if you want to look at this in another way, you can look at it in terms of the number of jobs, the workforce personnel that were involved, as well as the actual earnings that came from that. And that study showed that literally 27% of the jobs, over 800 people who worked on this project, were African American. That was just from the African American community alone. And 23% of the total earnings that were paid out for this project went to African Americans. So, and there were women who were involved on top of that.
Right.
And those figures are literally 3 times higher than any other project that the University of Cincinnati found had been built in the greater Cincinnati area. So I mean, the numbers were striking in terms of how these race-neutral means really increased the diversity and inclusiveness.
And I think I need to say this intentionality on the part of the Freedom Center goes back even long before the construction process. I was involved in the very early years as a consultant, and from the beginning it was always co-chairs, an African American and a white, of the board, of every committee, of every project that was undertaken. There was a commitment from the beginning, long before the bidding project. So it was really the intention again and the design, not so much of laws, but of intention of what the organization was.
Sure.
But that gets me to the another question. What about government and regs, and you have to deal with local, state, federal regulations, what can and can't be done? Can government, by writing regulations, really solve this problem, or is it really selling the idea of inclusion out to the private sector?
Well, that could be a long debate, Dan. I will tell you that in this particular project, I don't believe that any government regulation that existed at the time resulted in the success that we had. I mean, this was a privately owned project in the sense it was the Freedom Center, but there was local, Cincinnati, state, and federal money, as well as a lot of private money that was donated to make this happen. I guess the regulations and the efforts of governmental entities to try to encourage diversity are to be applauded. I think they're helpful, but I don't think in this particular project that they really were the key to the success. My point is this: we don't have to get lost in the regulatory battles. We can accomplish this, and probably more successfully, through just using common sense, race-neutral means to develop diversity and inclusiveness on any project, whether it's a public project or a private project.
We're almost out of time, just about a half a minute. How did it make you feel as a lawyer, as a person involved in this process with the success that you had in this area?
Well, personally, very, very good. My own personal belief structure and my life is such that, I believe we are all God's children, and He loves every one of us. And I want to see, every project that I'm involved in essence, be a microcosm of what I think society should be, and this project was.
Interesting to use this as a case study, a local case study that works. Thank you very much for coming down this morning.
Thank you.
Stay tuned. After the break, a conversation with a local judge who is making the leap from weighing Ohio law to weighing international law at the United Nations. Welcome back. Earlier this month, the United Nations moved to implement a 2007 plan to create an efficient and effective system of internal justice that will ensure individuals and the organization are held accountable for their actions. The UN created a two-tiered system consisting of a dispute tribunal with 5 judges with registries in New York, Geneva, and Nairobi, and an appellate tribunal with 7 judges that will sit in New York. On March the 2nd, 12 judges were named to these 2 bodies. They include 7 men and 5 women from Europe, Africa, Asia, North America, and South America. The only judge from the United States is Cincinnatian Mark Painter. Mark Painter served for 13 years as a Hamilton County municipal judge, and since 1995 has served as a judge on the Ohio 1st District Court of Appeals. Judge Painter is a graduate of the University of Cincinnati and the UC College of Law, where he has long taught as an adjunct. He is active on a number of local boards, and perhaps most importantly, he was once the proprietor of Murphy's Pub in Clifton Heights. That makes Judge Painter a member of Cincinnati's Saloon Keepers Party, which includes Jim Tarbell, Dave Crowley, and of course was once led by boss George Cox. Mark, welcome to Newsmakers. Welcome back to Newsmakers. How did this all happen? Did you hear about this opportunity? Or did somebody approach you about this? How did this get started?
I was reading The Economist magazine, and there was an ad. It was an ad for judges for the United Nations. You don't see very many ads for judges. No. And so it caught my attention, and I started reading about the system and what they were doing, a brand new court. And so I, by email, sent in my application to The Hague.
And what intrigued you about this? I mean, you've been, you're Cincinnatians we just described, you've been on local courts, now all of a sudden jumping to this. What is it that intrigues you about this opportunity?
Well, it certainly is a challenge because the first 7 judges in this appellate court, no matter how many rules or statutes you have, will pretty much shape how it works. And I was ready for a new challenge. I've been a judge here for over 27 years, and I thought it was time to do something a little different.
Mm-hmm. And what kind of cases? What is it that actually was going to come before? And you're on the appellate court. Let's make that clear. There's these 2 levels. You're on the appellate court. But what kinds of cases are going to be heard by these 2 courts and that will come before you?
Well, all of the employees of the UN, which is I think around 60,000 worldwide,
wow,
are not. The UN's not subject to any lawsuit. So if you think you've been discriminated against by your boss or by the company, or by the UN, or if they want to do discipline and enforce discipline, all of this, there's of course an informal system and everything, but then if you really want to go to court, this will be the court for all the employment issues, nepotism, things like that, corruption, all the things in the UN.
And how's this been handled up to this point? If there hasn't been this, if this is new, what's happened with these kinds of charges before?
There was more informal system, but it then had an administrative tribunal and administrative judges. They were not judges. They had been lawyers or professors or something. And then there was an appellate tribunal from that. But as I understand it, both sides, both the employees and the management, were both unhappy with it, that because they weren't judges, that the rulings weren't consistent. So you didn't know from one day to the other what was going to happen if you went into court, which makes everything more difficult if you don't know what the law is. So they decided, and it was a big reform a couple of years ago, appointed a panel of people to screen judges, headed by the Chief Justice of South Africa, Kate O'Regan. And they sifted through all the applications. They obviously advertised all over the world. I saw it in The Economist. I didn't see anywhere else. I don't know if they had it somewhere. And then narrowed it down to about 40 people. I think about 300 applied, and about 40 people. They flew us to The Hague. And we took an exam and then an interview.
Took an exam. Now, you've been a judge for 27 years, probably a long time since you took an exam?
The last exam I took was the bar exam in 1973.
So what was the exam about? Was it about procedural issues, or what was it?
It was very reasonable because what they did is they put us all in a room, with a computer, or you could write it, handwrite it if you wanted to. Some of the older people, and you could imagine that anyone older than I was, but there were a few, wrote it, but I used the computer, and they gave you a fact situation. So-and-so was fired or is complaining about this, and a couple things of rules and the UN Charter and some cases from this older tribunal, and said, write an opinion. You got 2 hours. And it was not an easy thing, of course.
Of course, for you, writing, clearly, writing within the field of law is right up your alley. That's what you've really pushed and helped try to teach younger lawyers, other judges, to write clearly. So in a sense, that particular exam was really perfect for you.
And I was surprised because the people on this panel, 2 or 3 of them did know me from that my reputation has gotten that far, or at least they looked it up.
Right.
And so I did that. And of course it was English, and it was the other people were a little disadvantaged, the people that weren't native English speakers, but everybody was pretty good at English. The court will work. The court will work in English.
Court will work. Okay, so common language. But what about the question of, these are judges coming from different cultures, but also different legal traditions. The role of judge is different in different traditions. As I understand it, say in a European system, the judge is much more active in terms of asking questions, even doing investigation. What's sort of the model for being judge in this situation?
This will be more patterned on the common law English and American system, because most of the judges are from that system, the ones that were picked. We have, I'm from U.S., there's one from Canada, one from Ghana where they have the British system, India, where they have the British system. So we've got a pretty good common law tradition there, I think.
Are you communicating with your fellow judges already about?
A little bit.
When does this start officially, and when does it start for you? When do you imagine moving on to begin doing this?
Well, it starts, both the trial court and appellate court start July 1, but it's kind of hard to believe that as appellate court you're going to have any appeals cases when the trial court has just started. Usually the trial process probably takes about a year. So the other thing they're going to do is have all the previous cases, they're going to try to get them all finished by the end of the year, but that probably won't happen. So they're going to pour all of the appellate cases over into the new system January 1. So we'll start out with a little bit of backlog that we didn't create. So there will certainly be plenty of cases by January 1, and that's when I envision there'll be a fair amount. My present intention at least is to wind up here on October 1.
Okay, so you will stay on the appeals court here in Ohio until October 1, and then move on.
We're trying to work it out so that there won't be a hiatus between, if I leave and a new appointee, because that kind of messes up our court.
And the sort of practical political side of this, when you do move on, that position will be filled by the governor, as I understand it.
Right.
The governor is now a Democrat, Governor Strickland. You're a Republican by backgrounds. That means the Democratic Party probably picks up the seat on the appeals court?
Yes.
Was that a consideration?
Certainly, but I don't think it'll hurt to have a little diversity on our Court of Appeals.
Okay. And do you imagine yourself moving to New York, living in New York? Is this going to take you, as I said, Cincinnati's all over your background. Is this going to take you out of the city?
No. A, couldn't afford to move to New York, and B, this is going to be it's not full-time. And one of the considerations is I'll be able to do a lot more of the writing and giving seminars all over the country, and actually I did one in Kuala Lumpur last year. I'd like to do seminars more, and of course, having a full-time job, that's hard to do. So this will be about half-time, I think.
So seminars in judicial legal writing?
Legal writing altogether for lawyers, yes. I'm going to beautiful downtown Des Moines in April. I'm doing the Kentucky Bar Association in June. I'm doing one tomorrow for the university. So I've got opportunities I could do more.
Okay. Well, Mark, good luck on this. It sounds really fascinating. It sounds like a great new challenge. It also means that you're not leaving Cincinnati, which is a good thing for all the rest of us who have known you for a long time and think you and Sue Ann bring a lot to this city. So it sounds like the best of both worlds for everybody.
Well, thank you.
So
thank you.
Good luck. And the UN, what a fascinating, I'd be really anxious to hear how this works out in the next couple of years.
It'll be different.
It'll be very different. Thank you for making Newsmakers a part of your Sunday morning. Next week, a very important show. I will be joined first by the members of Cincinnati Board of Health and then by the heads of the region's major private funding agencies who are coping with the fallout of the recession and the contraction of available private funds. Have a good week.